Senior Advocate of Nigeria, distinguished inner and outer bar, distinguished members of the press, ladies and gentlemen. It gives me great pleasure to welcome you all to the annual opening of the National Industrial Court 2022-2023 new legal year. Indeed, the importance in any climb of the National Industrial Court for labor dispute settlement, industrial coherence, and harmony cannot be overemphasized. The nuanced and the autonomous nature of the work that the court is mandated to deliver as a matter of law, and its role in supporting and entrenching industrial stability amongst both private and public sector employment institutions, despite disputes in our political and socio-economic landscape, no doubt lends credence to why the National Industrial Court has uniquely and distinctively stood apart from other superior courts of record in the Federation. Executing the clear vision of the court's mandate, which ranges from the basic fundamentals of prioritizing access to justice and the independence of the judiciary, to a keen cognizance and acknowledgement of international human rights instruments as they relate to employer-employee rights and obligations, promoting and protecting the integrity of employment institutions, ensuring consistency of decision-making, and ultimately modernizing the code in our contemporary times is in fact no mean feat. I must therefore commend my lords, the president, and all the judges of the National Industrial for your deep understanding of the many intricate realities of our labor relations, the forces that drive these employee-employer affiliations, and the motivations of the parties, both individually and collectively, in crafting very sound and sustainable decisions. Speaking of the court's pronouncement in recent times, particularly in the wake of the industrial action embarked upon by both the National Association of Resident Doctors and the Academic Staff Union of Universities, suffice to say that indeed the legal status of any strike action, let alone a protracted one, raises very crucial questions of law, and the approach with which the judges of the National Industrial Court have dealt with the related issues in making better provisions for promoting harmonious relations between workers and their employers is quite laudable. My lord, distinguished ladies and gentlemen, will recall the court's role in ordering an end to the recent strike action embarked upon by the National Association of Resident Doctors, wherein the learned trial judge ruled, among others, that no amount of money will be enough to compensate for the loss of lives that will be occasioned in the event that the strike is sustained any further. Sometimes having to prioritize on the greater good, determining merit or otherwise, by focusing on outcomes and its impact on the greater number of people in ultimately stabilizing agreements freely negotiated by employers and trade unions is an even more unique and daunting task of the National Industrial Court. Also valiantly calling to bear the inviolable duty of the court is your lordship's recent decision in the application for interlocutory order filed by the federal government in suit number NICN ABJ 270-2022 for the industrial action to be halted pending the determination of the substantive suit seeking the court's inquiry and adjudication on the legality or otherwise of the ongoing prolonged strike action by the Association of Staff Union of Universities, ASU. The learned judge, in fact, did well to consider the balance of convenience in according utmost importance to the value of education vis-a-vis education and tutelage for our teeming youth, and in fact, in the overall best interest of the nation. My Lord, distinguished ladies and gentlemen, I cannot end this address without alluding to the recent judgment of the National Industrial in the course of achieving this noble goal. Whether salary increment in public service can be attained in the manner sought to achieve it is still manner for doing a thing, no other manner resorted to will be legally compelling. Nevertheless, I wish to state that the patience, sacrifice, and the understanding of your lordships since the last increment 14 years ago cannot be taken for granted. Evidence clearly abounds to the fact that the current administration has manifested the requisite political will in key areas aimed at advancing the separation of powers, independence of the
Alaikum. Haka gane? Zazzaɓi ya rufe shi. Yana nan cikin ɗaki. Yana nan ɗakin malam. Wallahi ni ma shi nake. Kuma ga shi tun da safe kawai sai ana ta mana ruwa. Wannan sanyin wallahi. Wannan sanyin shi ya kara. Okay.